Hi, I'm Nadine Udorovic, partner at Nichols Family Lawyers, a boutique specialist provider of family law services with offices in Melbourne and Geelong. So today we're going to be talking about what happens when I go to court. Today we're walking through what happens when you go to court from the perspective of a family lawyer. If you're watching this, it is likely you're facing a situation where you may end up in court, whether it's about divorce, child arrangements, or financial matters, or you're simply interested in learning about the process. I know it can feel daunting, but I'm here to help you understand what to expect every step of the way. Before the first court hearing. So what most people might not be aware of is that most of the work is done before we even go to court, and the court process often begins with an application. Depending on the nature of your case, whether it relates to children, finances, or another family law matter, we'll make sure the appropriate application is completed and submitted correctly to the court. In most cases, especially involving children or finances, the court expects that you've at least considered mediation before you make an application to court. So if your matter proceeds to mediation before we go to court, effectively the steps will be that we will take detailed instructions from you in respect to your family law matter, whether that relates to parenting or financial matters. We will then liaise with the other party to arrange a mediation. Generally, the mediations that we facilitate here at Nichols Family Lawyers are barrister-led mediations with a mediator who's also a member of the Victorian Bar. We agree on a mediation date and we generally set aside the entire day to mediate. Each party comes along on the day with their respective barrister and solicitor, and there is a mediator appointed. Parties do not need to actually be in the same room together, and often for different reasons and circumstances we may need to facilitate the mediation at different venues, and we can accommodate all of those scenarios. In advance of the mediation, we'll prepare for you a draft mediation position paper, and that'll set out your position with respect to whatever family law matter we're dealing with for mediation. The other party will also prepare a mediation position statement, and those documents will be exchanged within a couple of days of mediation. They'll also be provided to the mediator. In advance of the mediation, we may also suggest a pre-mediation conference with your barrister so that you're comfortable and you've met with your representative before the day of mediation. We'll also ensure that all of the assets have been valued, that there's a balance sheet that's largely agreed, and those valuations also, in some circumstances where relevant, will also be provided to the mediator. So if mediation is successful, we generally will sign what's called heads of agreement at the end of the mediation, and then from there the heads of agreement will be used to draft court orders and/or a binding financial agreement or a binding child support agreement. And once those documents are signed by the parties, they get filed and registered in court and are generally sealed and made as final orders within a couple of weeks. And that is then effectively the conclusion of your family law matter. If your matter fails to resolve at mediation, then the next step is to consider making an application to court. So if we determine that after a mediation that hasn't resolved your matter and has been unsuccessful and there's no prospect of, for example, having an additional mediation to try and resolve the matter, the next step is to consider making an application to court. And that requires a certain number of documents to be prepared and filed. Generally, if you're the applicant, it's an initiating application with a supporting affidavit. It may also require a notice of risk if it relates to a child matter, and/or a financial statement if it's a property matter. Those documents we draft with you. Once they are signed, they're filed in the court, and we are given what's called a first return date, which is generally within a period of 4 to 6 to 8 weeks from the date of filing. Those documents then need to be served on the other party and/or their lawyers. From there, we will then consider engaging a barrister to appear on your behalf at that first return date. And we may also have some pre-court settlement discussions or negotiations with the other party. We'll also recommend that you have a pre-court meeting with your barrister. So arriving at court. So a lot of our court dates are actually run on Microsoft Teams. So first return hearings are generally all on Microsoft Teams. So you will not actually have to physically attend the court. But if you are going to court, for example, for an interim defended hearing or a compliance and readiness hearing or a final hearing, There are processes for arriving at court. So if we're heading to court, generally speaking, I'll recommend that my clients meet me at my office prior and walk together to court to meet our barrister. And our office is located a short 5-minute walk from the Federal Circuit and Family Court here in Melbourne. So we will enter the court together, we'll go through a security check, and generally we will have a private room set aside to speak privately with our barrister before the court hearing commences. So what does it feel like to be in the courtroom? So the family court is usually more private than any other types of courts. You won't be in front of a jury, and it's generally not open to the public. The judge or a judicial registrar or senior judicial registrar will preside over the hearing. If required, depending upon who is attending court to appear on your behalf, if it's myself, when instructed to, I will stand up at the bar table and put my appearance in on your behalf, and I will be there to represent you in court. If we do instruct a barrister for your case, they will be the one presenting your case directly to the judge, speaking on your behalf, examining evidence, and responding to the other barrister. Think of the barrister as the courtroom specialist, while I would remain involved closely behind the scenes, but also sitting at the bar table, preparing your case, advising you on strategy, and making sure everything runs smoothly. For example, at a final hearing, if there are witnesses, I'll be the one to liaise to ensure that the witnesses attend court on the day and time agreed. I'll also be there to ensure that the barrister has a properly prepared brief and have all of the documents ready as required, and to assist in any capacity required. So the outcome. So depending on the type of case it is, generally if it's an interim defended hearing, the senior judicial registrar or judge will likely make a decision on the day, or if not, they will stand down the matter to allow further negotiations or discussions between the parties on the day if it looks like a settlement can be achieved by consent, or they will simply reserve their judgment, and we would have to wait for a week, couple of weeks to receive that outcome. If your case goes to a final hearing, judges will always reserve their decision to go away and write their judgment. And generally speaking, you would receive your final judgment within 3 to 6 months. So after the hearing, we'll always explain to you what an outcome means if, for example, there has been an outcome given to you at an interim defended hearing, and what your options are from there, and whether it's moving forward to the next stage or complying with the court's decision if there are orders made on an interim basis. Obviously, where there's a final hearing, we would have to wait to receive the judgment, at which time we would discuss the outcome with you. So some final reassurances to our listeners. I know court can feel intimidating, but remember you won't be going through this alone. My job is to guide you through the process, protect your interests, and help you achieve the best possible outcomes, all at the same time as giving you advice along the way. And think of it as where you have a specialist team in the medical field. It's not dissimilar in the legal fraternity. So you often have a team of specialists, for example, your solicitor like myself, and your barrister as well, guiding you and assisting you through the process the entire way. At Nichols Family Lawyers, we understand that navigating any family law matter can be both legally and emotionally challenging, and we're here to support you every step of the way as you move forward into your next chapter.